So that takes us to due process, and the base of these rights, which really come from the 14th Amendment to the Constitution and the 5th Amendment of the Constitution, which provide that no state shall deprive any person of life, liberty, or property without due process of law. And these hearings are the way in which this particular governmental entity, the school board, goes about meeting its obligation to provide due process before it takes some action that might deprive someone of these rights. What are the essence what's the essence of due process? It's notice and an opportunity for hearing. My first real involvement with the legal process, actually before I went to law school, was working with the Department of Corrections when I was a college student. And even there, even inmates in a prison setting who are being disciplined have these basic rights of notice and an opportunity to be heard. And in that setting where security is a high level concern, that's about all the rights that they have. In a school setting, it's appropriate, or actually in any legal setting, for the scope of the hearing to be appropriate to the nature of the rights in question. And these basic rights of the opportunity of notice and opportunity to be heard can be enlarged by statute or agreement, but they can't be reduced. They typically are supplemented, and if you were to start looking through our statutes on the specific issues that we're talking about, and we're going to talk a little bit more specifically about them later, you'd see that there are lots of particular provisions that give rights to people in some of these situations. Student discipline is sort of the classic area where there is this right to due process, and the U.S. Supreme Court has said, and our statute tracks this idea, as do the state board rules, that since government has decided to give the right to education to students, an obligation it didn't necessarily have under the Constitution to begin with, that it can't withdraw that right without some fundamentally fair procedures. And so the student can't be suspended or expelled for more than 10 days without a due process hearing. One of the things I see happen from time to time is I see that right, that period of time get extended by agreement, but without agreement, it has to be done.
I have a question in regards to student discipline. When a student is facing a suspension or expulsion from school for 10 days or more, is the board under any constraints in regards to time frames into which they must render a decision?
Yes, the suspension can't continue past the 10th day without the board's decision. So pretty severe constraints unless the student waives them.
Richard, when you were talking about a student's right to a hearing for discipline reasons and suspensions beyond 10 days, how about disciplinary action taken against a student for something less than suspension? Does a student have any right to due process and or a hearing for being suspended from the football team for breaking training rules, which might include underage drinking or drug use?
I don't think that the case law as it exists has recognized that the student's property interest in those kinds of rights or privileges is sufficient to bring due process rights into play. I used a phrase there that seems a little odd in the circumstance, and that's the phrase property rights. That's where the courts began this application of due process to this sort of setting, and we don't ordinarily think of the right to play football as a property right, and I suspect the courts, as they're constituted right now, wouldn't find that right rises to the level that would require a hearing. But The law evolves.
If in doubt, hold a hearing. If you have a senior who is getting a football scholarship to LSU, and his ability to get that scholarship depends on completing the season successfully, and before the last game of the season he's found drinking, and you kick him off the team, thereby making it impossible for him to complete the season by playing all the games, thereby depriving him of a scholarship worth potentially, I don't know, $160,000. You might be better off to have a hearing to make sure you cross all the T's and dot the I's.
I put it a different way. Look at the underlying wisdom of the concept of notice and an opportunity to be heard. If you have great reason to punish John Smith, but it turns out I'm not the John Smith who did that, you might, as the decision maker, want to know that. And if you don't bother to tell John why you're punishing him and ask him what he has to say about it, you might not learn you've got the wrong guy. So I don't think this necessarily, even the kind of hard case you want to pose for me, is necessarily going to change the law, but who knows, on the one hand. On the other hand, in its bare minimum, it's just plain common sense to let people know what's happening and ask them what they have to say about it, I think.
Okay.
Obviously, termination of employment is the other critical area, and in the case of employees of school districts, because they're government employees, these due process rights may apply, whereas a private employee of a private business wouldn't necessarily, certainly wouldn't as a matter of constitutional law, have a similar right. So do all government employees have this right? The answer is no. The cases speak in terms of tenured public employees. And what does that mean? Well, tenured in this context means where law, the statute, or contract recognizes a continuing right of employment on the part of the employee, unless there's good reason to terminate it. So these rights don't apply to temporary employees of school districts or probationary employees, or employees, if there are such, and in some districts there are, who are employed at will.
Like administrators.
Well, most administrators in Vermont are not employed at will. Oh. And in fact, the next slide takes us to that point. Principals, tech center directors, and superintendents each have a statute that relates to their employment. The superintendent statute seems to be the one that's most flexible. It basically says, and I think probably each of the statutes could have said this perhaps more wisely than say some of the things that they do say, but the superintendent statute seems to say, well, they're employed in accordance with their contract.
Oh.
And once you have that contractual right during the term of the contract, you are a tenured employee. Your tenure may have have an end date on it.
Okay.
Obviously, the teacher statute is the place where we see the most action. We see that because almost all teachers in Vermont, or maybe all teachers, I'm not sure, are covered by collective bargaining agreements.
Almost all.
And so there is a watchdog in place to act on behalf of the teachers and exercise their rights under the statute, and they don't seem to be shy about doing that.
What if the party, whether it's a parent of a student, a teacher, or administrator, is not happy with the decision? What might we expect for them to do for a next step? Is there something within the Department of Education, public court? What's the next step?
Well, in order to answer your question well, we have to really put some context around it. The general answer is simple, and that is they might go to court, to challenge the board's decision in a particular matter. But just how they'll go to court and what arguments they're going to make, and what the impact of that will be on the board will differ from circumstance to circumstance.
Okay.
But there's nothing in the Department of Education, the commissioner, or anything of that avenue?
I'm not aware of any internal appeal of a student disciplinary matter to the Department of Ed.